नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
Times in the past, you must read the judgment. And when I say read the judgment, one way I gave you was to make your case summary. The second is, if you have a computer or if you have a smartphone where you are reading, okay, I know it's very expensive to print it out and all, it will cost you a lot of money. If you would like to print it out, print it out. But whatever, whether you're doing pen or paper, use that highlighting tool which is there in the computer or in the phone. Highlight, make your comments separately in a notebook. Why I'm saying this is constitutional law, we have about 50 cases in the case material. Uske alawa, I'll be referring some another few more. But even if we keep the 50 that we have to study, if you don't do regular study, just 2-3 days before the exam, your brain will become a khichdi. आपको याद ही नहीं होएगा कि ये वाला केस रिपग्नेंसी का है कि एग्जीक्यूटिव का है. It's inevitable. So the more you read, it will internalize it more. और केस के जो मोटे पॉइंट्स हैं, if you highlight and you understand that this is what it lays down, I think that constitutional law, it's not a difficult subject at all. The cases are there. It's perhaps bigger than many of your other subjects. This I will say. In an average paper, you may have 10, 20, 30 cases. But constitutional law will have 50 cases. What can we do? You just look. Every day the Supreme Court is giving a new judgment. Yesterday we all read the NLAT CLAT judgment, right? And today maybe the orders will come out on the Justice Chandrachud that hate speech and Sudarshan TV. We will have to read it. Everything is getting constitutionalized, so there is just no way you can escape reading. Okay, now let's begin with topic 3. Topic 3, we have some about 10 topics in our syllabus, 10 or 11 or 9 or whatever, I can't remember. Now topic 3 is dealing with the executive. So those students who are waiting outside, I'd suggest please give them this link so that they can enter. Now, okay, so now what does topic 3 deal with? It deals with the executive, but topic 3, topic 4 and topic 5 are closely linked. Executive and parliament are closely linked, and they are closely linked for the reason that we have the parliamentary form of government in our country, which is members of the executive of the government are also simultaneously part of the legislature. Therefore, you will find, if you look a little bit in detail in Unit 3, Unit 4 and Unit 5, that some of the cases in topic 3 overlap with topic 4. It comes as no surprise because some parts of a topic like office of profit could well come in executive, could also come in legislature. Because in our introductory classes, we had noted that there is no strict separation of powers in India. There isn't strict separation of powers in India. Therefore, there is this overlap between executive and judiciary. However, I want to point out to you before I continue further, if you look at Article 50, it tells us, executive and legislature shouldn't have been ENJ. Between executive and legislature, there is no strict separation of powers, which is why members of the government are also simultaneously part of the parliament or state legislature. We have the parliamentary form of government, which we have discussed earlier in class, is also in many books known as the Westminster form of government. because the Westminster is where the British House of Commons is, etc., etc. However, if you look at Article 50, and I just want to read Article 50, if you have your constitution, open it up. It tells you the state shall take steps to separate judiciary from the executive in the public services of the state. So my first preliminary point I want to make is separation of executive and judiciary is put down as a goal and a constitutional principle of state policy. But there is no separation between executive and legislature because Article 75 of our constitution clearly, I've written 74. 75 of the Constitution clearly incorporates the parliamentary form of democracy that we have, where the executive is answerable to the legislature. Therefore, you will notice that it's only E and J that are separated, not E and L. Now, two questions that I'm going to ask in today's class and seek answers for. Yes, please go ahead. However you want to get those other people in. You can do what you wish. Now, this is in response to a question somebody asked. Now, where am I? Yes. What is the executive and what exactly is meant by executive power? Okay. These are two questions that we seek answers for. I'll tell you what I'm going to do in today's class so that you know what I'm trying to do. What is the executive? What do I mean by executive power? And number two cases that I'm going to take up is the Ram Javaya case, which is there in topic 1, as well as the UN Rao case, which is there in topic 3. These are the two cases that I'm going to do in today's class to find out the answer to these two questions. Now, executive, instinctively we know by executive you mean the administration, you mean the government. In Ram Javaya Kapoor's case, the question got asked, what exactly do we mean by the executive? What is executive power? And it tried to answer this complex question in the way in which that it did. And I assume you've all read Ram Javaya Kapoor's case. In India, if you look at Article 53, Article 52 defines who is the president, but Article 53 uses a very special word. It says executive power is vested in the President of India. There is a word called vesting. This is very similar to Article 2 of the American Constitution. Okay, and I'm just reading out Article 2, Section 1. It says the executive power shall be vested in a President of the United States of America. Okay. It uses, the first time this word vesting was used. And our Constitution uses the same word. It says executive power of the Union shall be vested in the President and shall be exercised by him directly or through officers subordinate to him in accordance with this Constitution. Why I'm emphasizing this word vesting is, while executive power is vested, there is no similar power of vesting of legislative power or judicial power. There is no provision in our Constitution, unlike the American Constitution, which in Article 1 says all legislative powers shall be vested in the Congress of the United States. Article 1, Section 1. All legislative powers vested in the Congress of the United States. Now, the word vesting means that if it is vested in X, A, B, C, D, E cannot exercise those powers because it is vested in that person. Similarly, Article 3 tells us in the American Constitution, judicial power is vested in the Supreme Court of the United States. This is one of the ways in which we know that there is strict separation of powers in the United States. Once it's vested in Agent A, it cannot be exercised by Agent B, C, D, E, F. Okay, it cannot. Now, Executive power is vested in the president and in officers subordinate to him, meaning thereby nobody else can exercise executive power. That's number one. Number two, I'm letting you know that there is no formal of vesting of legislative powers in the Parliament of India or the state legislatures. When we come to that topic, legislature, you will notice that Articles 244 and 245, which deal with legislative power, don't use the word vesting. And there's a very definite reason for it. Because subordinate legislation is made by the executive. Some element of legislative lawmaking is in fact made by the Supreme Court when it makes the rules of the Supreme Court under Article 145. The different high courts make their rules of procedure. They are governed by their own rules. Therefore, legislative power is diffused. The Parliament is not in session. We have ordinances. For example, these farm bills that were passed day before yesterday. Earlier, the avatars were all ordinances that have been issued. Because legislative powers are diffuse and scattered over multiple sources, the word vesting for legislative power is not there. And that's the reason we also say that there's no separation of powers. And likewise, judicial powers also are exercised sometimes by the executive. When there are what we call quasi-judicial powers, these are also exercised by the executive. What do I mean by that? They take adjudicatory powers and decide. If you have a disagreement regarding your income tax returns, say with the income tax department, then it is the income tax officer who makes the first assessment and passes the income tax commissioner. If you have a dispute with the income tax officer, who's been the executive officer handling your case, you will go to the income tax commissioner, and the commissioner will be exercising quasi-judicial powers. We'll appeal to him, but he's a member of the executive, or she's a member of the executive, therefore. So it is in the executive that the vesting takes place. Now this executive power that is vested in the president under Article 53, subclause 1. So where is the vesting? Just to repeat, is there in Article 53. What is the executive power that is mentioned here? So 53 merely tells us executive power. Executive power is mentioned to us in Article 73. Where is my Article 73? There's no definition. It just tells you the extent of executive power. It doesn't define it. It tells you what is the extent of executive power. Is there a difference between a definition and an extent? There is. Because it does not tell you what are all the attributes of executive power which are contained, but it tells you over what you can have executive power. And when you look at Article 73, the first clause, please open Article 73, Clause 1. It tells you subject to the provisions of this Constitution, which means 73 is read along with every other provision of the Constitution. It doesn't stand in splendid isolation. Subject to the provisions of this Constitution, and this phrase is a very handy phrase. If you are standing and arguing in court and you want to use another article which is not dealing with executive power to explain your point, and judge says, why are you going? It is not dealing with the executive. If you are a smart lawyer, you will say, please look at the opening word, subject to the provision. And this gives me a gateway to draw on all the other 395 articles of the Constitution. Okay? And that's the reason we read the Constitution closely. No word is superfluous. That is one of the principles of constitutional interpretation. There is no word that is extra or just unnecessarily there. No word is rendered OTOs. Is another fancy word. Superfluous meaning extra, unnecessary. OTOs without any meaning. Bas maine dal diya. Sometimes when students write these answer scripts, right? They want to fill some pages, so they'll just say the same thing unnecessarily again and again and again. They think teacher is just sleeping and they're reading the answers. Sometimes those words are superfluous and odious. Okay. Subject to the provisions of this constitution, the executive power of the union, whatever I'm saying here will extend under 162 to the states. Okay, let's deal with center. Executive power of the union shall A. extend to the matters with respect to which Parliament has power to make laws. Straight away here, what are we doing? We are defining the extent of executive power not independently and of itself, but over all those matters over which Parliament has power to make laws. That is, it's relational. The extent of executive power is coterminous or identical with the areas over which Parliament has power to make laws. Now, this is a very odd, strange way of defining a power. You are not defining it in relation to itself. You are defining the extent of the power in relation to another organ, which is that of the legislature. Now, if we were to, why have they done that? We'll come to that. But the way of defining is by not looking at the executive, you turn your gaze and you look at the legislature. And you ask the Parliament, okay, tell me over what do you have power to make laws? Because exactly over that power, I as president have power of the head of the executive. Parliament has powers. If you don't know it, otherwise if you know it, it doesn't matter. We'll come to that later, but let me just now anticipate what we know already, which is the list 1, union list 1 and list 3, the concurrent list. So if we look at the 7th schedule, it tells you the extent over which the two, the central and the state, because we know we have a kind of a federal constitution with two lawmaking authorities. Parliament has power over the union list and the concurrent list, and state has over the state list and the concurrent list. So the answer is the extent of areas over which Parliament has power to make laws is contained partly in the 7th schedule, in list 1 and list 3. But why do I use the word partly and not completely? Because Parliament has powers to make laws which are not just in Article 1 and in Article 3. It has, for example, when we were looking at the nature of federalism, we looked at Article 249, 252, 253. Let me take these three for example. 253, for example. If the executive enters an international treaty that requires it to make a law, then Article 253 says, notwithstanding anything else in this constitution, it is only Parliament which will have power to make law to give effect to India's treaty and international obligations. So, if India enters into a treaty, and you will see a lot of comment nowadays on this question of agriculture, which we are grappling with. Agriculture usually is a state subject. Yet, if there is an international obligation that requires India to deal with some aspects of agricultural pricing, then it is Parliament which has the powers to make law with regard to 253. And we've looked at 249, 252, two or more states can come together in times of emergency, and there are more, 250, etc., 251, okay, all these things. So, this is also a power that Parliament has power to make laws over, but this is still not the full story. There are other articles in the Constitution which have given the power directly to Parliament to make laws without any reference to union list and state list. So I'm taking another article of our Constitution. We're not going to study it in detail, so I want to mention it here. Article 262, interstate river water disputes. If there is a river that flows through 1, 2, 3 states, each of these states is known as a riparian state. And if there is a dispute between any of these riparian states, then it is Parliament and Parliament alone which has the power to set up a interstate river water tribunal. Even though Water is a state subject. Even though groundwater is a state subject, even though rivers and canals and irrigation is a state subject. The river, when it is flowing within your state, is a state subject. But the moment it becomes interstate, 262 says, if there is a dispute and you want to set up a tribunal, Parliament. Okay. 35, Article 35. I'm just referring to Article 35 as one more article. Article 35 says, under our constitution, in the chapter dealing with fundamental rights, where offences have been created, untouchability is an offence. Untouchability is hereby abolished and the offence will be made. That offence, only Parliament will have the power to make an offence. Article 23 says, begar, forced labour is an offence. Who has the power to make a law over it? It is only Parliament. Parliament made the Civil Rights Act 1955. Parliament enacted the Protection from Atrocities, Scheduled Caste and Scheduled Tribes Act. Likewise, Bonded Labour System Abolition. Okay, so 35 gives that power to Parliament, even though labour is a concurrent list subject. Technically, a state could have also made, but it cannot make because Article 23 read with Article 35. Now, I've given you 3-4 instances now here. What have I put down? I've said, I asked you the question, what is the extent of executive power? We said under Article 73, 1A, over all those areas over which Parliament has power to make laws. Then we asked the question, so over what areas does Parliament have power to make laws? The most obvious one was the 7th schedule, union list and the concurrent list. But I told you that's only part of the answer. Then we looked at other articles where Parliament has got power to make laws, overriding the state, 249, 250, blah, blah, blah. Then there are some that are exclusively given to Parliament, never to the state. You see, 249 to 253 is overriding the state and giving it to Parliament. 262 and 235 never gave power to the state. It's clearly stated with the Parliament. So like this, there are some more, but this much is enough. So that's over all those areas. If Parliament has power to make laws, then the executive power extends over the similar areas. Come back to 73. Come back to 73 1A. B. Now come to 73. Okay, I'm just writing these things down so that you know where I am. Okay. Otherwise, sometimes students, when I don't have a blackboard, then this makes it easier. Right. So 73B. Can some student please read out 73B for those who don't have anybody just put on the mic. Okay. Samiksha Gupta, I can see you up here. Just read out 73 1B, please.
To the exercise of such rights, authority and jurisdiction.
73 1 from the beginning of 73, please, sorry.
Okay.
That those who don't have for whatever reason, but please buy a constitution or download it. Yeah, please continue.
Extent of executive power of the Union. 73(1). Subject to the provisions of this Constitution, the executive power of the Union shall extend A. to the matters with respect to which Parliament has power to make laws, and B. to the exercise of such rights, authority and jurisdiction as are exercisable by the Government of India by virtue of any treaty or agreement, provided that the executive power referred to in subclause A shall not, save as expressly provided in this Constitution or in any law made by Parliament, extend in any state to matters with respect in which the legislature of the state has also power to make laws.
Okay, stop there. Thank you. Now, what does B mean? A, I think is quite clear. Over all areas over which Parliament has power to make laws, executive power extends over that. What does clause B and its proviso mean? Samiksha, you just read it out. Do you want to explain to us what it means?
Ma'am, I didn't hear your question.
I said, explain what 73 means in simple words.
Ma'am, according to this, that the executive power of the Union will be extending to the power wherein the Parliament has to make laws.
That is A. What does B mean? B in the proviso.
Ma'am, won't be.
Who is this? I can't see your name.
Manu.
Manu. Yeah, Manu, please explain what you think.
Ma'am, won't 73B be covered rather by Article 253, which says legislation for giving effect to international agreements? So it is all covered under that, is what I suppose. I'm not sure, ma'am.
No. This is, I'll just come to that. And what does a proviso mean?
And the proviso is in relation to subclause A, which says that only the articles which are covered under state list, the Parliament won't intervene.
दोस्तों, ब्रास फ्यूजन आशा करता है कि आपको हमारा लेसन पसंद आया होगा। कमेंट बॉक्स में अपना फीडबैक देना ना भूलें। थैंक्स फॉर वॉचिंग।